name's Andrew Dudley, and this is Earth Live, a webcast featuring people working on the front lines of conservation and human rights. Today we're joined by Terry Collingsworth, who's joining us from DC. Hello, Terry.
Hey, how are you today? Thanks for your interest.
I'm doing great, thank you. So, welcome to Earth. So, can I ask, what is it that you do?
I am the director of the International Rights Advocates, which is a nonprofit legal advocacy group that focuses exclusively on trying to use different human rights laws or other laws, including local laws, to hold corporations accountable for human rights violations in their global activities.
And how did you get into this work?
Well, when I went to law school a long time ago, I was planning to be a union lawyer. I came up from a union family. All my relatives were all union officials, etc. So I thought that I would join the ranks of union lawyers. But during my studies, I realized that not that unions were irrelevant, but the new problem was that major multinational corporations were taking their jobs offshore to places where there were no labor laws. Initially, places like Indonesia and South Korea years ago, and now they're in China and Bangladesh and India and other places like that. So I decided to figure out a way to join with others to try to address the needs of workers in these unprotected countries where the companies actually went there for the purpose of exploiting them.
Incredible. And so next month you're going to the Supreme Court to against Nestle and Cargill. Can you tell us a little bit more about that case and what's been going on?
Absolutely. Well, in really the late 1990s, we started researching the presence of child slaves and forced child labor in the supply chains of all the companies that were getting their cocoa from Cote d'Ivoire. It was very dangerous then, that there was a civil war going on and so on. But long story short, the first thing we tried to do was pass a law in our Congress to outlaw the importation of cocoa coming in without some certification and verification that it was made without child labor. We passed our House of Representatives by a huge margin, bipartisan, Republicans and Democrats. And we caught the companies by surprise. And then it went over to the Senate, and they hired the biggest lobbyists in the world, and they ended up with what was called the Harkin-Engel Protocol. It was a voluntary initiative where the companies promised to someday, in 5 years initially, to stop using child slaves. Because of my supporters in the Congress and people that I had worked with on this, I pledged to wait for the 5 years to see. No, it was actually 4 years. They were to have ended by 2005. I knew they wouldn't. I was ready to go. And when the anniversary came up and they announced they needed another 5 years to stop using child slaves, we sued them. So that was in 2005, and I represent 6 kids who were trafficked from Mali to harvest cocoa in Cote d'Ivoire. And in those days, it was much more brutal than it is today. They were literally captured, kidnapped, and a couple of them tried to escape, and they were beaten and punished for doing that. And they eventually did escape back to Mali, and I was able to represent them. We filed the case in 2005. We have been to our courts of appeals twice. Both times we won resounding victories to go back to trial. And then the trial court just did not get it, was just perplexed and flummoxed by a case that involved Cote d'Ivoire and slaves. He kept figuring out ways to throw it out. We kept figuring out ways to beat him on appeal. This last time, though, we were certainly going to go back for trial. There was nothing left he could really do to us. And then the companies asked our Supreme Court to review the case. Now, our Supreme Court gets about 10,000 applications a year, and they only take about 200 cases. So the odds of them taking a case are very small. And unfortunately, they selected ours. And I say unfortunately because we were protecting a victory And so now there's the question of whether the Supreme Court will reverse the Court of Appeals and fine for the companies. The companies are making two outrageous arguments. The first is that corporations cannot be liable under international law, that you can only sue an individual person. And in our law, that is, it would be laughable if it weren't possible they would win that, because the corporations have fought in cases like Citizens United to get the right to lobby, the right essentially to vote. They have political voice. They are treated like a person for all other purposes, except they want this one exception. They want to be allowed to use child slaves. There's a second argument they're making that they are too far removed from the actions in Cote d'Ivoire, and you needed more U.S. participation. I think we're not troubled by that argument at all. We win it, but it would not devastate the law. If the court were to rule that corporations are immune, that would mean that all corporations are immune from all forms of law of nations violations. It would be a tragedy. It would give them permission, really, to continue to use child slaves and abuse people in many ways. So it's an important case.
Yeah, of course. And did Nestle and Cargill know what was going on?
From the very beginning, they had to admit that they knew what was going on. When they went to the Congress in 2001 to kill our law and make this Harkin-Engel protocol, the argument they were making is, yeah, it's terrible, we'll fix it. So they can't say they didn't know about something they promised to fix almost 20 years ago. And each time the deadline approached on the Harkin-Engel protocol, they came up with another excuse like, oh, it was way more complicated than we thought. We're still working on it. And they literally just gave themselves again until 2025 to stop using child slaves. And that's a total of 24 years where they've been doing it essentially with permission. It's just a remarkable situation.
Absolutely. So I understand that the basis of this case is the Alien Tort Claims Act of 1789. Can you tell us a bit more about that and how that fits in with the law of nations?
Yes. This law was passed by our first Congress in 1789. So the very people who wrote the Constitution and were the so-called founding fathers passed this statute. It has exactly 16 words. Essentially, it says an alien can sue in tort for a violation of the law of nations. The purpose, we all think, not from the legislative history, because they didn't have it in those days, but just from what was needed at the time. The purpose was they wanted to assure European traders that if their ships were hijacked by pirates off the coast of the United States, that they would have a forum to bring claims for recovery in United States courts. That was probably why it started. But the founders, these same people who drafted the Constitution, they were always forward thinking. And they used the word law of nations instead of piracy so that there would be the possibility of bringing other types of what were universally condemned acts. So piracy was at the time, but all civilized nations have since come to agree on some norms, including norms against genocide, trafficking, forced labor, slavery, torture, and extrajudicial killing. That's probably the list of the law of nations violations. And anytime I have the opportunity to debate a corporate representative who wants to try to kill the Alien Tort Statute, I always point out that that's a pretty short list, from genocide to slavery. Which of those are you worried about getting caught doing? And you'd think that you'd be sure you're not doing any of those. But they have gone after this law with a vengeance once we first used it in a corporate case back in 1996.
I find it fascinating that this law lay dormant for nearly 200 years until you guys got hold of it and started to see what you could achieve with it.
We were literally shocked. And if we have time, a brief story that I was approached by some Burmese refugees who had fled Burma then called Burma, now Myanmar. They told me the story that they were being forced to make a right of way for a pipeline of some sort, and these giant companies were there with the military of Burma, forcing them to clear the jungle and so on. So I interviewed these people, and I took their stories and went back to my office in Washington. And I had a law student then, a clerk from Georgetown University, and his name is Doug Steele. And I said, Doug, I don't know, dig around a little bit to see, international law claims and see what we can find. And he came back to me and presented me with a case called Philartiga, where some lawyers at the Center for Constitutional Rights had a year prior discovered this law, the Alien Tort Statute, and it fit perfectly to our situation, and we were the first to use it in a situation against a corporate violator.
And so I understand that in 2011 there was a circuit split. What was the significance of that?
Well, in 2011, we have a total of 12 federal circuit courts. There's 11 different numbered circuits, and then the D.C. Court of Appeals has its own circuit court. So that is often the function of the Supreme Court, to resolve disputes between the circuits. If all the circuits agree on a point of law, the Supreme Court doesn't need to get involved. So in 2011, the Second Circuit issued a ruling that corporations could not be sued under international law. And every other circuit disagreed with that and said that corporations could be sued, including in our Nestle case. In the 2016 ruling, the court specifically held that. So that was one reason why the Supreme Court accepted the case, because there was a circuit split. It's very hard for me to even put myself in the shoes of someone making that argument, though, because certainly going back to the Nuremberg tribunals, the U.S., the Allies put the Nazi criminals on trial, and they also put corporations on trial for supplying materiel to the Nazi regime. So that was one of the most prominent indications that under international law that corporations can be liable. But in our briefs before the Supreme Court, we cite cases in 1802 where shipping companies were corporations and they were applying this law, that there seemed to be no doubt until the corporations today thought of this clever argument that you might be able to show that international law is more narrow for corporate liability. So at best, it's a close question. And so this court is going to get a chance to clear that up one way or the other.
Thank you. And do you have a sense, since the passing of Ruth Bader Ginsburg, is that going to impact the potential results of this case, negatively or positively?
It certainly deprived us of a certain vote for justice. Ruth Bader Ginsburg was one of the greatest justices we've ever had for people who are human rights activists. She was very experienced herself and had brought a sense of humanity and empathy to her judicial chambers, which I think is appropriate. But in a prior case called Kiobo versus Royal Dutch Shell, she didn't rule on this question, but she did accept the premises that the Alien Tort Statute is a remedial statute. It was designed to provide a remedy for victims of human rights violations or law of nations violations. So that means that you should interpret it broadly in favor of the rights at stake. And so that itself would be a principle to apply here, that to narrowly construe the statute and to deprive the plaintiffs of an entire category of defendants based on really an interpretation that is not even appropriate in the statute, because it doesn't use the word corporation or not corporation. It doesn't say who could be the defendant, which we think means anyone can be the defendant. But yes, she would have been a certain vote. And we're not entirely sure how her replacement, Justice Barrett, would view these kinds of issues, but she is a very conservative justice.
Could we touch briefly on the Trafficking Victims Protection and Reauthorization Act, please? How is that different to the ACT?
Well, the main there are, let's say, two main differences. The Trafficking Victims Protection Act has been amended several times recently. The big amendment in 2008, and now another one in 2014, and it is very narrow in its scope in that it only applies to victims of trafficking and forced labor. So that's sort of the bad news is we can't use it in a torture case or some other kind of human rights violation, but we can use it for trafficking and forced labor. The good news is these amendments made very clear explicitly that it applies extraterritorially. So there's not going to be the debate there was about the Alien Tort Statute about when you can sue for overseas violations. And the statute is so specifically drawn that it would be very difficult for a justice or a judge who doesn't like the fact that you can sue a corporation for forced labor or trafficking to fiddle with the statute. It creates liability. Essentially, the operative term is, if we're talking about forced labor, any participant who benefits financially in a venture that uses forced labor or trafficked labor is liable. So there are some really great cases dealing with supply chain issues showing that if you are a company and you contract with a mining company or a chocolate producer and you know and financially benefit from the fact that they're using child labor, you're going to be liable. So we have a case already prepared that I will be filing shortly against Nestle Cargill, and we're going to add the other major cocoa companies, Mars, Hershey's, Berry Callebaut, and Olam and Mondelez, to sue them for forced child labor. We have new plaintiffs that were trafficked and that were forced then to work. So we're certainly sending us a message to these companies that we're not just doing this for some academic purpose. We want them to stop using child slaves. They've been promising for years and years and years to stop using child slaves, and we're going to use this new statute to sue them. I have a case I filed last year. I think it's the first one against like major corporate supply chains. We sued Apple, Tesla, Google, Microsoft, and Dell for their roles in using forced labor to mine cobalt in the Democratic Republic of Congo, where about 70% of the world's cobalt comes from there. And the facts are just startling how horrible it is in those mines. But a lot of children are getting killed and maimed that were forced to work in those mines. So I represent 15 families who either had a child killed or maimed in a mining accident against all of these companies. So we're going to use this statute a lot. I like it very much, and unfortunately, there are just too many examples of forced labor and trafficked labor that exists still today in 2020.
It's crazy to think about it. And during the research, I read about this new lawsuit against Apple and Tesla, and learning that the amount of money that these corporations are spending to defend these cases, for that same amount of money, they could really improve safety in the Democratic Republic of Congo. It's crazy.
It's crazy. Well, and the same with Nestle and Cargill. Since 2005, they've hired the most giant law firms that are in the world. These lawyers literally bill $1,000 an hour. I would estimate they have spent $35 to $50 million on legal fees since we've started. If they would have put $50 million on the table in 2001, we could have all worked together and fixed this, which is what I always said. But the corporations are just incapable of being told by someone like us to stop doing something. It just somehow does not compute with them. And the way they think is, if you can stop us from doing this, next you'll expect us to pay fair wages. I mean, they just want to stop any form of regulation at all.
Well, thankfully you guys are, taking these guys on. How big is your law firm?
Oh, we're very small. The International Rights Advocates is a small nonprofit. We have 3 lawyers. We then make the way we can stay alive and function without having me spending half of my time on fundraising or more is that I then make partnerships with other lawyers and law firms to join me in a case. Typically, I will do the field research and interview the victims and put all the pieces together, because I actually really find that meaningful, to meet the people and try to understand what's going on, to think about what we might do to address the problems. And then I can go to another law firm and say, I've done all the legwork, I'm going to file this, do you want to come in? And then they pay for costs and supply other lawyers to help with the case. In our Nestle case in the Supreme Court, I invited an old friend, Paul Hoffman, who's a lawyer in Los Angeles, to join me in the case. And we've been working together on it since 2005. And he, in fact, will be arguing in the Supreme Court. He's a much more experienced Supreme Court advocate than I am, although I have a lot of appellate experience. I thought we agreed that for this case, we wanted sort of the most experienced Supreme Court advocate we could get, and Paul fits the bill, and he's prepping as we speak with my help.
Brilliant. Again, good luck to you guys. So I guess the next question would be, what is the advice that you would give a CEO of a corporation like Apple or Microsoft?
The advice I would give is, first of all, don't listen to your lawyers who have an incentive to keep these cases going for as long as possible because they're getting paid $1,000 an hour. You might want to think about, are there ways to solve this problem? If you listen to some of these CEOs give their, sort of corporate pep talks, you got to get in a room and problem solve, think outside the box, blah, blah, blah. Well, this would be a good moment to do that. Instead of saying we're going to hunker down and fight this in court for 20 years if necessary, stop a moment and see who's talking to you. Like, maybe they do just want to solve the problem and not enrich themselves by suing you. That would be one thing. The other thing would be that for the most part, your brand is your life, and you ought to consider the possibility that if you're Apple or you're Tesla and you are really banking on young hipster type woke people buying your products because they perceive you as being green, clean, and futuristic, if they really process the fact that you are profiting from blood cobalt and that young children are getting killed and maimed in your supply chain, maybe you'd think about doing it a different way. That might be the better way to go. And I recently spoke at the Tesla board meeting because some folks bought some shares of stock to sponsor a human rights resolution. So it was a remote meeting, but Elon Musk was there. And I concluded my remarks by saying, if Elon Musk cared about these children who are being killed and maimed as much as he cared about his profits, the technology that he possesses would allow him to put drones and satellites above the mines that he gets his cobalt from, so he could see every second of the day whether children are working in the mines. He's not done that because he doesn't want to know. He doesn't want to confirm the facts that he does know, and that is that children are being killed and maimed to make him money. So greed is a factor here, but I think that even if you're appealing to greed, it's probably a better business decision to stop right now, figure out how to solve this problem, and get the benefit of the publicity of being a company that cares rather than just another company.
Exactly, makes perfect sense to me. So I have 2 questions for you, please, from a viewer, Atel Higgene, who's a human rights campaigner at an organization called Mighty Earth in DC. And her first question is, if Nestle and Cargill win this, does it mean the end of corporate accountability for human rights abuses in supply chains abroad? And will it remove legal protections for people, especially children, caught up in slavery?
It will have those effects, at least in the short run, because it'll probably cause a surge of non-compliance by corporations. I'm very proud that several people I know that work for corporations or that represent corporations, they've told us that we were responsible with my partners, all the people like me doing this work. But most corporations now have a corporate social responsibility department that is looking after their codes of conduct and so on. Now, a lot of that is just public relations scams. But there are some companies that actually have stepped up compliance because they were afraid they would be sued. So that's going to go away, at least for a while. But what we will do, I want the CEOs and the upper management of Nestle and Cargill in particular to get a strong message from us. Not only are we going to sue them under the trafficking law, which does apply to corporations, but we're going to sue them individually. If they want us to sue a human, well, then we're going to sue the CEO of Cargill and the CEO of Nestle and say, congratulations, you won in the Supreme Court. It's not something that they think we won't do it because they don't have the billions of dollars in assets that Nestle and Cargill do, but we're not doing this for money. We want to stop child labor, so we'll make them be the accountable faces and see how that goes. In the long run, we need a legislative fix if the Supreme Court completely decapitates the Alien Tort Statute. And our politics right now are very precarious. We will have a President Biden, but whether we get the control of the Senate remains up in the air, and whether we are able to get our issue to their attention, because there were so many issues that are backed up after 4 years of Trump, is a legitimate question. But we're certainly going to keep pushing in the courts and legislatively to make sure that corporate accountability doesn't disappear forever if it disappears temporarily because of this court.
That brings us to Attel's next question. She says, or she asks, do lawyers like Terry need a law that squarely bars human rights abuses and deforestation in high-risk supply chains entering the USA? And is that what is needed to protect victims of abuse like this?
Absolutely. We have been working with other groups, including Mighty Earth, on the cocoa issues. And I think if you put 3 or 4 of us in a room together, we could design a perfect statute that would close the loopholes created by the prior Supreme Court decisions that harmed the Alien Tort Statute, and then expand the protections that we're attempting to do with law. We want to protect human rights, but the environmental degradation going on in the cocoa harvesting, for example, is equally a serious problem that affects people. If you take away the trees and the vegetation in a place like Cote d'Ivoire that is terribly poor, you're damaging air quality, you're causing erosion. There are so many issues that affect the health and safety of people. So yes, our fantasy was we would get a huge election win. People would get rid of Trump and the Republicans in the Senate who supported him, and that we could then have a legislative approach easily won. Now we're going to have to work a bit harder for it, but that is absolutely the necessary step we need to take.
And just in closing, for a young person that's interested in a career in law and especially human rights, what advice would you give them?
Well, first of all, I would say that if you want to do it as a lawyer, unfortunately, it's very difficult in the United States to make a living as a human rights lawyer because we're the nonprofits and the other side has all the funds. But it's possible, and I feel that it's important to say that the value I get every day out of waking up and feeling like I am using my skills, however meager they are, but I'm applying them to something I believe in 100%, that gets me just filled with joy every day that I get to do something that's helping people with my law degree. That is invaluable. So when you're looking at comparative salaries, you've got to imagine that you will be able to reflect on your life having helped people and helped to solve the problem rather than protecting these corporations that are causing all these issues. The second piece of advice would be, it's almost impossible as a new lawyer right out of law school to knock on my door and say, I want to be a human rights lawyer, because you don't have any skills yet. And we aren't in a position, and I know of the other organizations doing this in the United States, like Earth Rights, doing litigation, and Center for Constitutional Rights, to name a few. We tend to be looking for people who've developed some litigation skills so that when you come to work with us, you have those skills. The fact that you're going to be a human rights lawyer does not change the fact that you need to have the skills of a lawyer. Whether you're doing corporate law or trusts and wills, if you're litigating it, you need to know about evidence and the federal rules and just the practical side of it. So it's good to get that experience first, and then start volunteering initially with a human rights organization as a pro bono lawyer. And then once they get to know you, that's the easiest way in. I think I've hired every lawyer I've ever hired because somebody came and volunteered to help me on a case. I got to see how devoted they were and how good their skills were. And then when I actually needed and could hire a lawyer, I hired from people that I knew in that way. So be patient, try to find a good role model, and get some skills. And it's a very rewarding way to spend your career.
Thank you. And the last question, do you have a book that you would recommend to people that's kind of inspired your journey?
Well, thank you for that question. I actually, if you can see from my background here, this is my first library. I've got several around the house, but that reading is kind of my passion. But I would say, looking back on what inspired me as a lawyer, I was inspired by the civil rights movement and the lawyers that were the driving force of the civil rights movement here in the United States. And foremost among them was Thurgood Marshall. I sometimes think I have like a case in Alabama against an Alabama coal company, Drummond, that used paramilitaries to murder people in Colombia. Every time I'm going down there, I'm thinking like, I'm definitely don't have the home field advantage here. Then I think of Thurgood, and he was driving around Mississippi and Alabama in the late 50s, well, really the early 50s, litigating these school desegregation cases and public housing and all kinds of accommodation cases. That took real courage, and he was just an excellent lawyer. So there's I'm sorry, the name of the author escapes me, but there is a definitive biography of Thurgood Marshall that I read while I was in law school, and that really inspired me that if he could do that at that time when it was so much more difficult and dangerous, that there's nothing that should be holding us back as we try to hold corporations accountable.
That really is fascinating, and I'll be sure to check that book out, and we'll also provide a link to it at the bottom of the video as well.
Well, after we hang up, I'll send it to you.
Excellent. Thank you so much, Terry. And again, thank you for your time today. It's been really fascinating, and good luck to you and your team in the Supreme Court next month, and keep up the fantastic work. Thank you.
Thank you very much. And if you could put out my website on a communication, sure. iradvocates.org, I'd be happy to respond to inquiries and keep people. You can keep yourself advised of our Supreme Court case by looking at our website.
Excellent. All right. Once again, thank you, Terry, and stay safe.
Thank you. It was a pleasure, and I appreciate your interest. Take care.
If you enjoyed the content today and would like to watch more videos like this, please subscribe to our social media channels or join us at www.f.live/join.